Employer zero-tolerance marijuana policy is justified termination. A federal district court agrees, you guys. Very interesting. A zero-tolerance marijuana policies are not unlawful in Illinois. A federal district court has determined, providing greater clarity for employers. In late 2019, Illinois amended its marijuana law, the Cannabis Regulation and Tax Act, the CRTA, to ensure employers could continue to implement policies prohibiting workers from using marijuana or marijuana products despite the state's decision to permit adult use marijuana use. Nevertheless, you need to mute all of them. Nevertheless, the extent to which employers could enforce their policies in possible conflicts with Illinois' law prohibiting discipline for unlawful non-work activities remained. A new court decision, White versus Timken Gears and Services Incorporated, number 21 CV 2290, has answered some of these questions, providing further support for Illinois employers that have adopted and want to continue to enforce zero-tolerance policies regarding marijuana. The employer company develops, manufactures, and sells industrial motion products such as aggers, gear drives, and transmissions. The company implemented a drug and alcohol policy that prohibited the unlawful manufacture, distribution, dispensing, possession, or use of controlled substances or alcohol in the workplace, and the policy defined controlled substances to include marijuana. The employer also required employees at its manufacturing and distribution centers to undergo random drug screenings. The policy provided that an employee, upon a first-time positive test result, would be required to participate in consulting. In counseling, sorry. They say, stop using the substance for which they tested positive, and we need to hit play. Yeah. And submit to unannounced follow-up testing. A second positive result would subject that employee to immediate termination of employment, you guys. The plaintiff's employee worked for their employer as a territory account manager in that role, and he worked from the home selling products and repair services, but also drove a company car to customers' facilities, you guys. On December 6th of 2019, the employee tested positive for marijuana on a random drug test, and he participated in the employer's employee assistance program and continued to work during that time, except he was not allowed to drive a company vehicle. On January 6th, 2020, it's a popular date, look at that, the employee was required to submit to a follow-up drug test, and the result was negative. On January 21st, 2020, the employee was required to take another drug test, and this time the result was deemed a negative dilute, which the employer treated as a failed test. The employee was allowed to take a retest, and his result was again deemed a negative dilute. The employer was unable to reach the employee via a phone afterward, and the employee did not respond to the company's email to him. On January 27, 2020, the employer permitted the employee to undergo a second retest, and his result was positive for marijuana. As a result, the employer terminated the employee's employment, citing his violation of the drug and alcohol policy. The employee filed suit against the employer for allegedly violating the IRWPA, this whole bunch of code and whatnot, and this case was removed to the U.S. District Court of the Northern District of Illinois. The IRWPA prohibits an employer from firing an employee because the individual uses lawful products off the premises of the employer during non-working and non-call hours, and 820 ILCS 55/5A. As of January 1st, 2020, cannabis is a lawful product under the IRWPA. However, Illinois' Cannabis Regulation and the Tax Act, the CRTA, addresses employment and employer liability for conduct relating to the use of cannabis under state law. Section 10 through 50 specifically addresses what actions employers can take regarding cannabis-related violations. those provisions were central to the court's analysis of the employee's claims against the employer, and engaging in statutory interpretation, the court identified 3 key provisions from Section 10 through 50 of the CRTA. First, the CRTA authorizes employers to adopt 2 types of drug policies: a zero-tolerance or drug-free workplace policies, or employment policies concerning conduct in the workplace or while on call. The court emphasized that the CRTA authorized adoption of either type of policy and that a zero-tolerance policy needed to be limited to employees in the workplace. Second, the CRTA states that employers may discipline or discharge an employee for violating their employment policies or workplace drug policies, and the court stated that this provision not only authorizes employers to adopt drug policies, but it also authorizes employers to terminate employees for violating them. And third, the CRTA precludes employees from bringing claims against an employer for certain actions taken pursuant to their drug policies, including reasonable and non-discriminatory random drug testing. The court stated a plain reading of this provision indicates that an employer may enforce its drug policies through random drug testing so long as the testing is 1, reasonable, and 2, non-discriminatory. The court summarized these provisions as follows. Employers may adopt a zero-tolerance or drug-free workplace policy. Zero-tolerance or drug-free workplace policies need to be tied to, in quotes, in the workplace conduct, such as policies may be enforced through reasonable and non-discriminatory random drug testing, and an employee may be terminated for violating the employer's drug policy. Applying this interpretation to the case at hand, the court determined that the employer had adopted a permissible zero-tolerance policy that it enforced through random drug testing. Therefore, in order to prove a violation of the CRTA and, in turn, the IRWPA, the employee needed to show that the employer's actions were either discriminatory or unreasonable. The court concluded that the employee had not made such a showing and therefore granted summary judgment in the employer's favor, you guys. Explaining its reasoning, the court observed that the employer had not selected the employee for testing based off a legally protected characteristic, so the employer's policy and enforcement could not be discriminatory. As for reasonableness, the court noted that the employee had acknowledged receipt of the employer's drug and alcohol policy, which advised him of the company's drug testing procedures and potential consequences for violating that policy. The court also noted that the employer did not immediately terminate the employee for a first-time positive test and critically allowed the employee to provide a negative test result before conducting additional follow-up testing. After further observing that the employer granted the employee more chances to comply than its policy then required, the court concluded that both the employer's policy and its implementation of the policy were reasonable. Because the employer's policy and actions were neither discriminatory nor unreasonable, the court held that the CRTA allowed the employer's actions resulting in the termination of the employee's employment, and the employee could not maintain a claim against the employer under the IRWPA, you guys. Illinois is one of numerous states that has legalized adult use marijuana. Despite early uncertainty regarding the interpretation of Illinois' laws around marijuana use, the court's interpretations have helped clarify that employers can still implement drug-free workplace policies, including zero-tolerance policies, and enforce them, including by requiring random drug testing. And the Timken case further demonstrates that Illinois' employers' zero-tolerance policies are not restricted to prohibiting only in the workplace conduct, and adverse action can occur as long as it is not unreasonable or discriminatory. Still, some employers are well advised to closely review their drug-free workplace and testing policies and, if necessary, revise to ensure that employees are aware of the employer's expectations regarding drugs, including marijuana, and potential consequences of a policy violation, you guys. Well, this guy lost his job for a failed drug test, and man, oh man, he tried to fight it and got handed to him in court, and I can't wait to hear what you guys have to say about this.
Well, we don't have a hell of a lot to say because we missed a large portion of it. But I mean, it sounds like they gave this guy a couple other chances to provide some clean pee. He was like, here's the rules, just to go over it again. We agree, right? Pee in this cup. You're all good. And then all of a sudden, he did it again and again and again and again. He's like, I can't believe they fired me.
I mean,
is that what the article kind of said?
So basically, this guy is claiming that he used cannabis on his off time, apparently, from my understanding of this, and he produced a positive and then was given the opportunity to retry the test. But I'm not sure what a negative dilute test means. That I don't.
It means that he put some water or something in there to try to make it.
Oh, he tried to cheat. He tried to use like the water weenie or something.
Yeah.
Oh, okay.
Fiddled in the pee, dog.
Got it.
Yep. A couple of those in college.
Oh, okay. All right. That makes a lot of sense.
Why didn't this guy just get a Whizzinator?
Yes.
Like, put the little bottle between your butt cheeks. The hand warmer will keep it good till you drop it off in the cup. You're not going to watch your wiener.
I did after they had a could not determine. They only had cloudy piss, and then they brought it back in there.
Well,
that's when the Whizzinator,
your
properly
test was for athletics, right? Though, Rico, your test wasn't from an employer.
Yeah. Don't matter. Same
exactly.
shit.
Yeah, no, that's different rules though. There's different rules. Employers, for employers and whatnot, they can't follow you into the bathroom like they can with college.
Yeah, they don't watch your TT.
Yeah, they can.
No.
Yeah, they can. They did when
depends on the industry.
Yeah, they did when I did a drug test for one of my old jobs here.
I just wanted to see your wiener, Rico.
There were a bunch of Peter gazers, huh, Rico?
Like, I don't know why I got a drug test every day, you guys. This is weird.
Watching is hot these days, I guess. You know what I'm saying?
So this guy did everything but go get some clean piss. Like, I'm sure that I've got some guy friends, especially during my pregnancy, they passed the drug test. They might have popped for pregnancy, but they passed the drug test, and I helped them out with that. So, I mean, like, this guy
you did not help any guys pass a drug test. That is not true because male pee and female pee is very, very distinctly different.
Well, they clearly didn't check.
A female pee is pink.
You can test the liquid for chromosomes.
Yep, exactly. Thank you,
Yarrow. I don't think that the little sensor that does like the pre-drug screening $5 test is really doing all that much.
So here's the challenge, right? And to me, here's the rub, right? On the one hand, we don't want. No, you stop it, young man. On the one hand, we don't want government intruding and interfering with how private businesses run their businesses. And so this CRTA, this whatever that stands for, help me out here, the Illinois Cannabis Regulation and Tax Act.
Why does it matter?
The CRTA gives broad latitude to private companies to adopt their to enact their own drug policy.
That's correct.
And it says whatever your drug policy is, that's mostly okay with us, right? And so we can understand why we don't want the government interfering in everything. And on the other hand, it doesn't provide protections for employees for what they do when they're not at work, off of work time. And so that's an inherent problem that would likely come up someplace. And so I'm not surprised that in 2024 we're covering this case from 2019 that has slowly worked its way through the court systems, because what that wide latitude in allowing employers to determine their own policy, what that wide latitude has given is a lane for them to fire somebody for activity that didn't occur while they're working and is state lawful. And that's unfortunate.
Yeah.
Fair enough. And all.
Well, the biggest thing this points out to also is that the flawed methodology of the test, because the cannabinoids sit in your fat cells. It's not like an alcohol or other drug test where if you test positive, you're actually under the influence. If you're a heavy smoker, especially if you're doing like dabs and stuff, you can test positive for weeks. So they still are yet to come up with a test that accurately reflects if someone is actually on cannabis and high or not. Which mainly they should do the Oreo test, right? Like come in for your drug test, like, dude, you want some Oreos, bro? Eat more than 4 Oreos, you're fired.
That's
Fair
fucked
enough.
up, Jenny. Come on.